Good evening, everyone. Welcome back to another episode of Vital Descent. I'm your host, as always, Patrick McFarlane. This one is episode 279. Show notes may be found at vitaldescent.com/279. And in this episode, we're going to be talking about a landmark jury verdict that came forward in the case Shamari v. CACI Premier Tech Incorporated. This is the infamous Abu Ghraib torture prison plaintiffs. Three named plaintiffs in the lawsuit got a hallmark victory either today or yesterday, awarding millions of dollars to them for human rights abuses committed upon them at the infamous Abu Ghraib torture prison. And before we dive into that, though, I'm going to be going through the history of Abu Ghraib, the history of the case, and talk a little bit about what this means going forward for human rights abuses committed by military contractors abroad, American military contractors abroad. Does this open the floodgates potentially or cause some hesitation on behalf of the United States military, how they conduct war crimes abroad, how they conduct, their torture programs abroad, but also how they conduct any other activities, because having military contractors that are so intimately involved with the process of intervention overseas, all of a sudden now they can be sued for human rights abuses and torts, negligence, things like that, intentional infliction of pain, or severe emotional distress, or other civil causes of actions. They're wide open for liability now, it seems like, based on these rulings. So I think this is very interesting, something to tackle for this podcast here. First, though, I just want to talk about Scott Horton's new book, Provoked: How Washington Started the New Cold War with Russia and the Catastrophe in Ukraine. Go check it out. I'll put a link in the show notes page here. Go buy a copy on Amazon or from your bookstore or something like that. I think you can buy it directly from us. I'm not exactly sure over at the Libertarian Institute, but I know you can get it from Amazon. It's live on Amazon right now. Last time I checked, it was number 32 overall in all books on Amazon. It's number one bestseller in War and Peace right now, but when I checked, it was 32 overall for all books on Amazon. So go pad those stats there. Get yourself a copy, something that you really will need. It's been 2.5 years in the making, but you're going to need it because Biden just approved that U.S. long-range missiles can be used by Ukraine to strike inside Russia. And this is a huge, incredible provocation that Putin historically had said would mean war. So we'll see how that play out. I don't necessarily think it will lead to war, in fact. However, doesn't mean it's not dangerous and we shouldn't be concerned with it. So the Center for Constitutional Rights in this case, this landmark jury verdict that came forward, filed a lawsuit that has actually been 16 years in the making. So we're talking about a lot of things in this show that have been years long in the making. Here's the fact sheet. Torture at Abu Ghraib and Al-Shamari v. CACI. This is a federal district court case in the federal judicial branch, the federal system, the federal judicial system. They're broken up into federal district courts and federal appeals courts and the Supreme Court, as you are all pretty familiar with. But it's broken up into the district courts are where there are the trial courts, much like your state court. We've talked about this before on the show if you want to go back, but at the trial level court is where trials are had and fact-finding happens and testimony happens and exhibits and juries and all those things that you'd be familiar with from watching, I don't know, what are those stupid criminal TV shows, Law and Order or something like that. Reality is very different from the TV shows, but that's where in federal courts where you have either a federal question or a controversy involving citizens of different states, involving more than a certain amount of money, those things happen. This is a federal question. Either that, I'm not exactly sure. Like, I would think it would be a federal question, or it would be, someone who, because of their diversity among the states, would be subject to the jurisdiction of the court. So you either have federal question jurisdiction or diversity jurisdiction. Federal question would be like, I don't know, abuses of federal law or questions involving violations of federal law. And then diversity is just like, oh, well, these defendants don't fall under the jurisdiction of a single state because the controversy is over $150,000 and you have citizens of two different states or foreign citizens. And in this case, we do have foreign citizens. So I'm not going to go into the minutia of jurisdiction too much because it's in federal court and you could get on like a long tear on that. So the invasion of Iraq and torture and abuse at Abu Ghraib. So here's kind of the backgrounder here. And I was going through Scott's books to try to, take a quotation from it to give a little bit of background. He writes about it in Enough Already, his second book about the war on terrorism. So I'll just touch on that just a little bit. But here's the fact sheet. The invasion of Iraq and torture and abuse at Abu Ghraib. In March 2003, the U.S. unlawfully invaded Iraq using a false claim that Iraq had developed weapons of mass destruction to justify the full-scale invasion. Measures taken by the Bush-Cheney administration before and after the invasion led to the complete political destabilization of Iraq and a U.S. established governing body formed in its wake. The incalculable human toll of the Iraq war continues to grow, hundreds of thousands dead, millions displaced, environmental devastation, chronic generational medical conditions, countless people tortured, traumatized, or otherwise harmed in ways unseen, and an entire generation raised with endless war. Soon after the occupation and the ensuing insurgency, the U.S. began a mass roundup of Iraqi civilians, the vast majority of whom were never charged with any crime, and set up a prison system around the country. Abu Ghraib, a notorious prison outside of Baghdad, previously used by Saddam Hussein's regime to deploy torture and cruel treatment, was opened as a key detention site to hold Iraqi men, women, and children. Inside that sprawling detention center was a 2-floor concrete prison, the hard site, as it was called, where Iraqis were detained, interrogated, and ultimately tortured. In April 2004, news outlets broke the story of the torture of Iraqi prisoners detained by the U.S. at Abu Ghraib, releasing photographs and video showing naked hooded detainees posed in human pyramids, prisoners on leashes, and widespread sexual assault. Images so horrifying they are burned into the consciousness of a generation, or at least they should be. The revelations drew demands for accountability and redress from around the world. Subsequent military investigations led to the court-martial of a small number of low-level U.S. soldiers, as well as documentation of the role played in the torture at Abu Ghraib by private military contractors from 2 U.S. corporations, Titan Corporation, later known as L3 Services, and Ingenuity Corporation, and CACI, Premier Technology, Inc. The invasion of Iraq and the torture inflicted at Abu Ghraib did not happen in a vacuum. Following the attacks on September 11, 2001, the Bush administration declared a global war on terror. This deliberate manufacturing of a foreign enemy who holds dangerous ideological beliefs led to the creation of the Department of Homeland Security, a massive increase in anti-Arab, anti-Muslim hatred, and a variety of discriminatory policies and practices targeting African, Arab, Muslim, Middle Eastern, and South Asian communities at home and abroad. It was also used to justify increased U.S. militarism across the globe, beginning with the invasion of Afghanistan and later Iraq. So the background to the case. Al-Shimari v. CACI Premier Technology, Inc. is a federal lawsuit brought on behalf of 3 Iraqi torture victims against U.S.-based government contractor CACI Premier Technology, Inc. The lawsuit alleges that CACI participated in a conspiracy to commit unlawful conduct and including torture and war crimes at Abu Ghraib, where it was hired by the U.S. government to provide interrogation services. The plaintiffs, Suhail al-Shimari, Asad Zubai and Salah al-Ihali were all held at the hard site, an area of the Abu Ghraib prison where the most severe techniques were used in 2003 to 2004. This case is brought under the Alien Tort Statute, so there's your federal question, and filed in the Eastern District of Virginia, where CACI is headquartered. So there you have your venue and your federal question. The U.S. law from 1789 allows non-citizens who have been subjected to well-established violations of international law, such as torture and cruel treatment, to bring a case in U.S. federal court, including against a U.S. corporation where there is a sufficient connection to the United States. The lawsuit alleges that CACI is liable for conspiracy to commit cruel, inhuman, or degrading treatment, torture, and war crimes, and for aiding and abetting these acts. The plaintiffs are seeking compensatory and punitive damages. So compensatory damages are basically to make the victim whole. Like, I don't know, if you were hit by a car and the other person was on their cell phone, you had medical bills probably, you probably have pain and suffering, and you are seeking compensatory damages to make you whole, meaning that to put you in a position that you were in as if the vehicle had never hit you. Now, of course, they can't turn back time, turn back the clock and undo it, so they provide money. Punitive damages, on the other hand, are to punish bad behavior. And in this case, punitive damages, the jury found were appropriate. Of course, there's lots of motion practice that happens in the case before you get to a trial, where the court will decide if punitive damages are even on the table. Are we going to let the parties argue for or against punitive damages? Are we going to let the even allow that question get to the jury, where they get a jury form and they say, are punitive damages appropriate here? Yes or no? And if yes, then how much, and how much for each client? So continuing here with the case, since the case was filed in 2008, so it was filed in 2008, that's a long time ago. I was in high school. I was a freshman in high school in 2008. CACI has tried to dismiss it more than 20 times, invoking a range of legal defenses and immunities that argue at the core that CACI should not be held liable for conduct, even if unlawful, done in Iraq while working under contract with the United States. This case has gone on appeal to the Fourth Circuit 5 times, and after it failed to have the case dismissed, CACI brought a Supreme Court review, which was denied. So these are called interlocutory appeals. So in a case where you have filed a lawsuit and you're on the path to trial, and there's a question that you thought that the judge got wrong, you can file an interlocutory appeal so that that decision can be reviewed before you go to trial. And you would appeal up to the appellate court. Usually it's about procedure, or whether or not certain evidence should get into the trial, or whether or not a party should be dismissed from the case, because summary judgment, basically says, well, a plaintiff would file a summary judgment motion saying that, or I guess either side could file saying that the facts are all undisputed, but if the facts are as the other party says they are, well, then I'm still entitled to relief as a matter of law, because they're basically admitting all the points of my case. This happens through pleadings, or if the paper's on record, like the depositions or exhibits. There probably wouldn't be exhibits filed in the case, but there'd be depositions or the pleadings. If they show that the facts are undisputed, or that at least the area of agreement is out there, agreed upon through pleadings or depositions, if those show that there's no genuine issue as to a material fact, one party might be entitled to judgment as a matter of law. There could be a motion to dismiss, as in this case, saying essentially that, well, the court has no jurisdiction over the U.S. government, because the U.S. government hasn't been they haven't provided their consent to be sued, which is sovereign immunity, which is something that we're going to get into just a little bit here in a minute. So they brought all these the CACI brought all these guns out in order to avoid this, essentially. It's gone on appeal. I'll repeat myself, but it's gone on appeal to the Fourth Circuit 5 times. And after it failed to have the case dismissed, CACI sought Supreme Court review, which was denied, essentially saying that one of the times it was appealed to the Fourth Circuit, CACI did not get the answer they wanted from the Fourth Circuit, so they petitioned the Supreme Court of the United States to make a decision in this case, interlocutory, before a trial decision, and the Supreme Court denied it and said, no, basically, the appeals court got it right. We're not going to handle the case. The Supreme Court has 3 times narrowed the scope of the Alien Tort Statute since this lawsuit was filed, but the case has survived. In 2018, Judge Leonie Brinkema found that plaintiffs have sufficiently pled and had evidence to support their claims that the case should proceed to a trial for a U.S. jury to decide the merits, and reaffirm this decision after the Supreme Court's Nestle ATS decision. In April 2024, the case finally proceeded to trial. After 8 days of deliberation, the jury failed to reach a unanimous verdict, and Judge Brinkema declared a mistrial. A new trial is scheduled to begin on October 30th. Well, guess what? That new trial concluded either today or yesterday with a finding for the plaintiffs. So the mistrial happened in the first one I read because the jury could not decide if the U.S. government was responsible for the mistreatment or if CACI was responsible for their mistreatment, because CACI was basically arguing that, well, our contractors, yes, there are employees, but when they are there, they are subject to orders from the U.S. military. So because they were acting under orders or direction or supervision of the U.S. military, therefore CACI shouldn't be liable, and the U.S. military is or should be. And the jury couldn't decide if it was CACI or the U.S. military. Was probably a ununanimous finding by the jury, or that there wasn't a majority or something like that. So the problem being is that if the jury finds that it was the U.S. military that was primarily responsible, and the contractors were not, then there can't be a recovery for the plaintiffs because, oh, well, guess what? The U.S. military is immune from being sued, so I guess you're just out of luck. So CACI's role in torture and serious mistreatment of Iraqis at Abu Ghraib. Their role in the torture is well documented. Army Major General Taguba investigated allegations of detainee abuse at Abu Ghraib, and his 2004 report concluded that between October and December 2003, quote, numerous incidents of numerous incidents of sadistic, blatant, and wanton criminal abuses were inflicted on several detainees, and that military intelligence and CACI interrogators instructed military police to set the conditions for detainees' interrogations. MPs have testified that it was understood amongst CACI interrogators and soldiers that softening up and special treatment equated to serious physical and mental harm to detainees. The Faye Jones military report, released in August 2004, concluded that military police, medical soldiers, and civilian contractors had some degree of responsibility or complicity in the abuses at Abu Ghraib. At least 3 CACI employees were cited in the report for abusive behavior. Evidence obtained through this litigation, such as emails, court-martial records, and deposition testimony, shows not only the role of CACI contractors in abuse, but that CACI refused to act on specific reports of misconduct perpetuated by its employees and instead covered it up. That's probably maybe part of where the punitive damages come from. Despite CACI's claims to the contrary, there is credible evidence that it aided or abetted or otherwise contributed to a conspiracy to torture and abuse the 3 plaintiffs as a matter of U.S. and international law. CACI seeks to deflect responsibility for interrogators' misconduct from itself to the U.S. Army by claiming it was the military that controlled CACI interrogators and ordered detainee abuses. This is what CACI calls the borrowed servant defense. However, this is not what the law says. Even though CACI was working with the U.S. military, the corporation still exercised control over its employees and could hire, fire, discipline, and supervise them. Therefore, CACI should be held accountable for its employees' roles in the abuses. It is rare for foreign victims to be able to bring their claims against U.S. corporations all the way through to trial, which is why more than 20 years after 9/11 and the invasion of Iraq, this is the first lawsuit where victims of U.S. torture and cruel treatment will have a trial in a U.S. courtroom. The plaintiffs, Salah Assaad and Suhail have spent 16 years fighting for justice in a U.S. court, and now they have the chance to tell the story of what happened to them in hopes of some accountability. Last paragraph here. Accountability for torture by private military contractors. Over the last 2 decades, private companies have made billions by providing vast services in Iraq, Afghanistan, and the surrounding region, ranging from security escorts for government officials to intelligence gathering and analysis to logistical support. The post-9/11 wars have been the most outsourced in U.S. military history. Currently, there is no sufficient contractor or accountability and oversight system in place. While the U.S. Department of Justice has responsibility for investigating and prosecuting international crimes by contractors, it has been rare for DOJ to bring any charges against contractors, and none have been brought for torture or war crimes. To read more on the Center for Constitutional Rights prior cases against private military contractors, see these cases. So, Selah v. Titan. I wonder if that's the same one that they were talking about before. Yeah, very interesting verdict here. Going back, let's see, there is a page here. So this is the page here for the actual case filings, and I just thought it'd be interesting to bring up the verdict form. So here's the actual copy of the filed verdict form. You can just see the jury found, basically, judgment hereby entered in favor of the plaintiffs against the defendant CACI in accordance with the jury verdict dated November 12th, 2024. Judgment is in the amount of $3 million in compensatory damages and $11 million in punitive damages as to each plaintiff. So I think that's huge. So I'm going to get a little bit into kind of the more personal side of who these plaintiffs are and kind of paint that picture a little bit. I saw an article here tweeted out by Stella Assange from The Intercept. Abu Ghraib detainees awarded $42 million in torture trial against U.S. defense contractor. By Sanya Mansour is the author over at The Intercept. The jury awarded a total of $42 million to 3 Iraqi men, a journalist, a middle school principal, and a fruit vendor, who were held at the notorious prison 2 decades ago, Abu Ghraib. The plaintiff suit accused Virginia-based CACI, which was hired by the U.S. government to provide interrogation services at Abu Ghraib, of conspiring with American soldiers to torture detainees. A rare victory for plaintiffs who want to bring suits against American corporations for playing a part in the country's so-called war on terror. Here's a quote. What the jury did today is send a very clear message that the contractors who go to war or go work with the government overseas, they will be held accountable for their role in whatever violations their employees may commit, said Catherine Gallagher, a senior staff attorney at the Center for Constitutional Rights, which represented the plaintiffs at a press conference on Tuesday afternoon. Quote, they need to have far better oversight over their employees to ensure that something like what happened at Abu Ghraib never happens again. The case hinged largely on the legal definition of conspiracy, which doesn't require an overt act, but can also include cooperation with others engaging in torture, Stepan Mestrovic, a sociology professor at Texas A&M University, and expert witnesses in multiple courts-martial of soldiers who served at Abu Ghraib. This ruling opens the door to future findings of responsibility based upon conspiracy to commit war crimes by civilian contractors and other adjuncts to military forces, he said in an emailed statement. CACI had argued that while abuses did occur at Abu Ghraib, it was ultimately the army who was responsible for this conduct, even if CACI employees may have been involved. The defense contractor also argued there was no definitive evidence that their staff abused the 3 Iraqi men who filed the case, that it could have been American soldiers who tortured them. Notice there is no deny. I mean, of course, you can't deny based on the evidence that there was torture taking place while they were there. But the jury didn't find that argument persuasive. The monetary compensation for plaintiffs, yeah, we already went over that. Their lawyers say that's what they requested. Baher Azmi, legal director at the Center for Constitutional Rights, said in a press conference on Tuesday that the verdict sends a strong message that this kind of corporate malfeasance and neglect and reckless and deflection is outrageous and deserves to be punished. So, yeah, really, really incredible. Now, I tend not to put a lot of stock in what reporters say about things going on in the law. That's why I always kind of, I don't know, in the show I've tried to read cases or read opinions about lawsuits that are actually coming from people who are attorneys or who are in the know. I think in one of the, I've done like how to read a U.S. Supreme Court case. I think if you go back to vitaldissent.com and look at what I've talked about in the past when I've covered these things, things to do with the court. The last one I'm looking at is like, I don't know, there was some benchmark Supreme Court case that came out within the last year that I've talked about. Just can't remember exactly what the name is right now. So let's talk about the sovereign immunity claim, because I think that might be what a lot of people are wondering is like, okay, well, how come these detainees can't sue the U.S. government? And I'm sure they tried. But here's the document in Shamari v. CACI Premier Tech Inc. Now, this is a huge, like, you can't see how many pages this is, but it's an incredible amount of pages. But here's some of the law that follows this. So, under Federal Rules of Civil Procedure 12b1, a civil action must be dismissed. Every time I zoom, it changes my place. And I want you guys to be able to read it on the screen for those on YouTube. Oh my God, okay. The civil action must be dismissed whenever the court lacks subject matter jurisdiction. The plaintiff has the burden of proving subject matter jurisdiction. Because jurisdictional limits define the very foundation of judicial authority, subject matter jurisdiction must, when questioned, be decided before any other matter. That's the question of, well, does this court have the power to hear this case that's before it? So, Federal Torts Claims Act waiver of immunity. CACI first contends that the Federal Torts Claims Act has waived the government's immunity for the claims at issue in this case. In response, the government argues that the foreign country exception operates to bar tort claims. The FTCA generally, so I think in this, it sounds like CACI is trying to keep the U.S. government in the case, because if there's another person, another party, they're both co-defendants. If CACI, they're pointing the finger at each other. This is like the meme where Spider-Man, there's like 3 Spider-Mans and they're all pointing at each other. This is kind of what it sounds like CACI is doing with the U.S. government, trying to keep the U.S. government in. So the Federal Tort Claims Act generally waives sovereign immunity and subjects the U.S. to liability for tort damages caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of his office or employment. under circumstances where the U.S., if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred. Congress has provided a variety of exceptions to this waiver, including for any claim arising in a foreign country. CACI argues that the foreign country exception does not apply to its claims because the area where plaintiff's claims arose, Abu Ghraib, was a location in which the sovereign government had been forcibly displaced by the U.S. military and its allies, occupied by the U.S. military forces, and governed by a military occupation government. So again, usually, so the U.S. government is saying, CACI, and sorry, this is a little complicated, but CACI is saying that the Federal Tort Claims Act is a bypass to the government's sovereign immunity for these claims. But the government is saying that the foreign country exception operates to bar the tort claims, meaning that, well, these acts, normally if these acts happened on U.S. territory, then we would waive government sovereign immunity, but these acts happened in a foreign country, which means that sovereign immunity still applies and that the tort claim shouldn't go forward, essentially, that there's sovereign immunity because that this loophole through sovereign immunity has been closed because these acts took place in a foreign country. And CACI is saying, well, they took place in a foreign country, but still that country was under U.S. occupation. Although the court did not clearly define the phrase foreign country as used in that section in a former case, in a different case they're citing, it relied primarily on considerations of sovereignty, stating, "We know of no more accurate phrase in common English usage than foreign country to denote territory subject to the sovereignty of another nation. By the exclusion of claims arising in a foreign country, the coverage of the Foreign Tort Claims Act was geared to the sovereignty of the United States. Although this decision indicates that territory subject to another country's sovereignty is categorically within the limits of the foreign country exception, it does not explain how the FTCA treats territory that is subject to no or overlapping or ambiguous sovereign claims." So the court goes on to talk about like other cases and how they treated places like Okinawa under U.S. occupation and how they treated Antarctica under U.S. occupation, basically saying that it was within the foreign country exception. So that's how the United States is getting out of this. Essentially saying that, well, the Foreign Tort Claims Act bypasses sovereign immunity. The fact that the torture took place in a foreign country means that there is no bypass. So the sovereign immunity still applies. There is no bypass. You can't sue us because the tort took place in a foreign country. But also, that's because of this interpretation of how recent court decisions have found places like Antarctica and Okinawa. So this is what the court concludes, that when these decisions are read together, it becomes clear that Abu Ghraib is in a foreign country, in quotes, within the meaning of the statute, and remained as such during the time it was occupied by coalition forces. In many ways, its status mirrored post-World War II Okinawa's, as the United States and other coalition governments displaced the previous Iraqi sovereign. Abu Ghraib, like Okinawa, was never, quote, incorporated into the United States, and given the concept of foreign country embraced in Smith, another court case they talked about, the lack of an independent Iraqi sovereign does not bar the application of the foreign country exception, meaning that the foreign country exception applies and you can't sue us because the tort took place in a foreign country. Accordingly, the Foreign Tort Claims Act does not waive sovereign immunity for the tort claims asserted in this civil action. So CACI goes on to assert another argument, essentially that for sovereign immunity should not apply because there's this fabric of international law that goes across the world that, according to those international law norms, that states cannot just go against those international law norms and legislate that they can't be sued. That this is a special type of claim that because of those claims, because of this type of claim, the U.S. government, it's so bad that the U.S. government can't just say, well, we're immune, you can't sue us, screw you, goodbye. That argument was also denied. But there's a really interesting discussion here of sovereign immunity that I think is going to, I think it'd be useful for you guys in the audience to know about this or understand it a bit better, because it goes to explain why a lot of these cases are so hard to bring. As why they're hard to bring and why it's hard to rectify criminal rights abuses or any kind of, we've talked about a myriad tort, this whole Oppenheimer documentary that I'm still trying to work on, but struggling hardcore. Behind the Fog. Remember that one where we talked about chemicals being sprayed over the United States, different cities in the United States, and the plutonium injection experiments, those kind of things. Why it's hard to sue the government for those, because they just say, well, sovereign immunity. So CACI further argues that the government has waived sovereign immunity for violations of jus cogens norms. That is, those preemptory international law norms from which states may not derogate. This question appears to be one of first impression, meaning that courts haven't grappled with this argument before. Not just in this district or circuit, but nationally. Accordingly, before the question, so it's a novel legal argument within the U.S. federal courts. Accordingly, before the question presented may be addressed, it is necessary to examine the history and development of sovereign immunity doctrine and jus cogens norms to contextualize the current dispute. Although plaintiffs and not CACI were the victims of the alleged jus cogens violations at issue in this suit, CACI argues that its claims for indemnification, exoneration, and contribution are derivative of plaintiffs' claims against CACI. That basically means that CACI wants to be indemnified from the suit, meaning that they want the U.S. government to indemnify them or protect them against this lawsuit, to exonerate them, which sounds like it. Yeah, everyone knows what that means. And contribution, meaning that they want the U.S. government to contribute to any claims that are found against them by the plaintiffs. Accordingly, CACI appears to assume, and the government does not argue otherwise, that if the government does not have immunity for jus cogens violations, and thus plaintiffs would be able to bring their claims against the government, CACI may recover from the government on its derivative claims. As discussed below, various federal courts have confronted the question of whether foreign states may invoke sovereign immunity in federal court with respect to alleged jus cogens violations. These cases are not helpful for two reasons. First, they are primarily concerned with interpreting FISA, Foreign Sovereign Immunities Act, which codifies a doctrine of foreign sovereign immunity in American courts. By contrast, the immunity of the American government from suit is a common law doctrine. And the question meaning that, sovereign immunity, I've talked about it on this show before, that it's just something that is ingrained in the common law. All these decisions going back to time immemorial, whenever we have developed our entire English legal system to say that sovereign states are immune from lawsuits. And the question whether the U.S. has waived sovereign immunity for jus cogens violations does not turn on the interpretation of any one statute. Second, domestic and international law treat the questions whether a sovereign is immune from suit in its own courts and whether a sovereign is immune from suits in the courts of a different country are distinct questions. So those are two different questions. In particular, the serious concerns that would arise from any rule allowing a country to be sued in foreign courts the world over, as well as considerations of comity and respect, may incline in favor of a rule of restrictive jurisdiction over suits in courts of a foreign state, but that do not apply similarly to suits in domestic courts. So they're saying, you got to take into account, if we allow this, if the U.S. government is going to basically allow suits against it in foreign courts, it could be disastrous. Like, you want cases to proceed in foreign courts against the U.S. government, meaning that the U.S. government would be subject to liability in courts that it has no control over, where like I don't know if you guys have ever heard of the Amanda Knox case. It's a criminal case in an Italian court, but it's just like a kangaroo court, and they have no due process understandings, no like equal protection understandings, and it's just like a free for all. Well, if the US government would allow itself to be sued in like an African tribal court or something like that, it'd be ridiculous. Like it'd be a difficult to understand and to figure out how wild and crazy that would be. Now, I don't know, maybe there's an argument to say that, well, if we were sued in a Japanese court or something, or, an English court, then maybe we would allow that. But how would you pick and choose, and by what criteria? I don't know. So I don't know. Like, I want to get into all this, but I also don't. So it's fascinating, the development of sovereign immunity. I guess just going back to English common law as early as the 13th century appears to have its roots in England's feudal system, in which each petty lord in England held or could hold his own court to settle the disputes of his vassals. Although a lord's vassals were subject to the jurisdiction of his court, as the court was the lord's own, it could hardly coerce him, right? So it's just a matter of like what happened, because his vassals were beholden to him, and it shouldn't be the other way around, because that would be disastrous, right? Indeed, the trusted counselors who constituted a lord's court could claim no power over him, their lord, without his consent. That being said, each petty lord was vassal in his turn and subject to coercive suit in the court of his own lord. In the organization of the feudal hierarchy, the king, who stood at the apex of the feudal pyramid and was not subject to suit in his own court, was wholly immune from suit because, quote, there happened to be no higher lord's court in which he could be sued. With the rise of the nation state, this personal immunity of the king transformed into the immunity of the crown. Given the potential harshness of such a doctrine as attached to the crown rather than the king, legal authorities developed procedures whereby victims could obtain redress for wrongs committed by the government without directly suing the crown. For example, when a government agent committed a tort, English courts permitted suit against the government official or employee who had actually committed the wrong complained of. Wouldn't it be nice if we had that? Indeed, in such situations, the doctrine of sovereign immunity is embodied in the famous phrase, "the king could do no wrong," ensured that the tort victim could obtain a judgment against the agent. Theoretically, if the king could do no wrong, it would be impossible for him to authorize a wrongful act, and therefore any wrongful command issued by him was to be considered as non-existent and provided no defense for the dutiful agent. Similarly, English law developed the petition of right, which allowed subjects to petition the king for the ability to sue the crown in the king's courts, in effect asking the king to waive sovereign immunity with respect to a specific legal dispute. As with tort suits against government agents, the notion that the king could do no wrong worked to ensure the availability of a remedy for victims of wrongdoing, because the king, as the fountain of justice and equity, could not refuse to redress wrongs when petitioned to do so by his subjects. So that's a really interesting legal argument turned by its head, right? In this podcast, we've talked long time ago when I was in law school about the importance of the Magna Carta, and going all the way back to Lysander Spooner and trial by jury, talking about this development in the English legal system of how we would first it was divine right of kings, right? That God literally, or UFOs, came down from the high heavens and selected a bloodline of rulers on this earth to rule over the rest of us, and their power was sovereign, and it was endowed by God or our creator, or by, essentially by their bloodline and their ability to rule. Because, at some point in time, just having a big stick isn't enough. And in our development of, Western liberty and freedom, We go from might makes right to divine right of kings, that God bestowed this upon me. And then the Magna Carta starts to say, okay, well, hold on a minute. We have to have some authority for limiting the supreme power of the monarch. That has to be that if the monarch is selected by the king, or excuse me, the monarch is selected by God, then the monarch the authority comes from God, so therefore the monarch has to act godly. I think that's what the argument is. In this one, it is, well, kings are the fountain of justice and equity. They're endowed by their creator with this power, so surely they could not refuse to redress a wrong when petitioned to do so by his subjects, right? So this is when, the minions, when the serfs start to clap back a little bit, say, well, surely there must be some redress here. Then it becomes a matter of necessity a bit more so, where it's like, okay, well, king, you really don't have any power without your court and your lords and all of your feudal lords, and they won't go along with you if you decide to do something that they don't like. So you really only have power when you're sitting with the court, when you're sitting with your lords and lieges and all that stuff. Then it becomes, the part of that is because of the purse strings, and part of it is also like you need the cooperation of the men you're going to send to war and who are going to pledge their men to fight wars with you. And then we get this idea of, in the British, the English Civil War, the levelers come out, and the levelers have this idea of, well, there exists something inherent in our humanity with, like the Enlightenment thinkers and, John Locke and all these people who in libertarian theory we think of, where they say, well, we are born and endowed with certain unalienable rights. And this is incredibly radical, by the way, that the king cannot touch those rights because they come from God. And, if the king is put into place by God, it's kind of an extension of that original argument that I just read. The kings are the fountain of justice and equity. Okay, well, where does the king get his power? Well, God has bestowed upon him the right to rule over everyone else. However, God also has created man with his certain unalienable rights that are inherent to his humanity. Wow, I didn't think that we'd be going all the way there. But I'm not going to go more and more. I mean, I think it's a fascinating part of this decision here that we've been talking about. And I'll put a link in the show notes page for you guys to read that section of it. It really is very interesting. So what does this all mean? I mean, what does it all mean going forward? I think this is a huge case, and I think that its importance can't be understated. Now, the plaintiff's lawyers did explain that even throughout the pendency of this case, the Supreme Court narrowed the Federal Tort Act. I forget what it's called. The Foreign whatever Tort Act, Claim Act, that one. The FT, the Foreign Tort Claim Act, narrowed the scope of who could sue under, like, which foreign nationals could sue under the Foreign Tort Claim Act. And so that window is getting smaller and smaller, but still these plaintiffs broke through that window, and they were able to establish, go all the way to trial and get a verdict from the jury in an award for damages from a private contractor. That's huge, I think, because sitting here, and I don't have statistics to kind of back this up, but hell, the U.S. military probably couldn't do what it does today without contractors. I think contractors are an incredibly large part of logistics in foreign countries, in the U.S. empire. And I mean, for instance, we have American contractors being deployed to Ukraine to service weapon systems we have American contractors, the famous Blackwater mercenaries that are actually, providing security and doing other things, that are torturing people, that are probably kidnapping people and disappearing them, doing things like that. But also maybe more mundane things like, I don't know, refueling naval ships, or I'm just pulling this out of my ass, but refueling and restocking naval ships, or working on, weapon systems, or providing translation services, or doing things like that. I mean, you name it, I'm sure that U.S. military contractors are doing it abroad. And, I think that our friend, we meant well, Peter, why is it not coming to me? He was a U.S. military contractor in Iraq trying to oversee like the civilian U.S. interaction. And Peter Van Buren, there he is. And when you have a window into recourse for war crimes or torts or, terrible, horrible, nasty nasties going on abroad, you have this window to come through. And I think that it might have a chilling effect, or at least it would make U.S. military contractors be more alert and aware of this possibility that if they don't hide their malfeasance more carefully, they could be sued. I say that because I don't necessarily think it will have a chilling effect where it will prevent malfeasant conduct on behalf of contractors. I don't know. Maybe we'll see more develops there, but it is very important. I think it's good. It's good to see some justice be done for these three plaintiffs and some of the horrible things that happened to them. Essentially that they were being, tortured in solitary confinement for a long time, that they were put in stress positions, that they were beaten, and just some of the worst treatment that you can imagine. So really is great. The show notes for this, again, will be found at 279, vitaldescent.com/279. Just a little note on kind of where I'm at. I know it's been quite some time since I released an episode. I apologize for that. But I don't know, to be honest, it's just been hard to write about stuff, or with the election cycle and kind of the state of the liberty movement, and also with getting dragged down just with, work at my law firm. I took a few high profile cases and very serious cases defending people, and, with my kids and everything, it's been really difficult. And kind of inspiration comes in waves where I work really intensely for a couple weeks and then I get burned out. And I mean, anyone following the show for a number of years will kind of be aware of this, I suppose. I'd like to be doing more stuff, but it's just I have a lot on my plate. And yeah, so I'm working on some fiction stuff. I'm also still working on the Oppenheimer documentary. Ideally, I'd be able to, get one of those done every other month, or one done a month. But it's just, they're so time consuming, like tens of hours that I just don't have. I mean, the last thing, when you have kids, I don't know how many of you have kids, and plus being a business owner and a lawyer, it's like I get up in the morning and I start with the kids, and then I go and work at a very stressful and demanding job as a small business owner, which has its benefits. But then you get home and it's dinner, and then kids don't get to bed until like 8 o'clock or 8:30. And then it seems like, the last thing that I feel like I want to do is go downstairs and work for another 2 or 3 hours. I know some people do that, but it's just difficult. I could either go watch TV with my wife, or read a book, or do things for myself, or work for another few hours. So, and then getting stuff done during the day is really difficult, because it's like, well, constantly the phone is ringing and people are coming in, and then there's another fire to put out here, and then someone doesn't show up to court, and then I'm stuck in court. Like today, I was stuck in court for 3 hours doing various sentencing arguments about sentence credit. So it's just hard. So I appreciate your guys' patience and your support. My membership website is still up and running, vitaldescent.club. You can go check that out for newsletters and then early access and other bonus content up there. If you hit subscribe in the lower right-hand corner, you get thank you credit at the end of episodes and documentaries and a thank you email from me. And then that early access as it applies to things. And not to be forgotten, everyone, here's all my supporters and subscribers. I really appreciate you. Chandler, Andre, Philip, Jesse, Jan, Andreas, G. Cross, Virginia, Scott, Troy, Nick, Melanie, Ovidiu, Donald, Zygodactyl, Connor, and Lee. Thank you, everyone, for continuing to support me through this. Not giving up on the show, still finding things to write about, getting stuff out there. Topic ideas would be appreciated, and ideally things that I don't have to spend a really long time getting to the bottom of before I do a show on it. Okay, vitaldescent.com/279. Go out and buy a copy of Provoked, How Washington Started the New Cold War with Russia and the Catastrophe in Ukraine by Scott Horton. Thanks, everybody. Peace.